Danielle, who's new, Danielle Sujcik, is new to the ZBA as an alternate, and this is her first meeting. So everybody be nice to Danielle.
Hi, Danielle.
Welcome.
And we have Marilyn, that's 3. We have Tom, that's 4. Who am I missing here?
Okay, so Chris says he's going to bow out now since he had another engagement. So
Yeah, just let's make sure we got 5 more. So we got me, Marilyn, Tom, Lee,
Danielle.
Danielle. Okay, we're ready to go. I'm going to call the meeting to order. And what I'm going to do is ask everybody who isn't speaking to keep their mic muted. When you want to speak, go ahead and unmute your mic. And starting in the evening, I introduced our new member, Danielle. And Danielle has just joined us like a couple days ago. So she could use guidance and from Amy and myself and Lee, and we're ready to rock. Let me read what I have to read to start the meeting. Members of the public can call in and issue. Everybody hear me fine?
Yeah.
Yes.
Wave at me if you do. Call in and listen to a meeting. They will not be able to speak or see any of the meeting participants. Each meeting will use a unique meeting webinar ID. Please find the information using the link above. And the link above is our Norwalk City website, norwalkct.org /1913/meeting-notices. Members of the public who wish to provide live comments will need to register in advance and use the Zoom meeting platform. All participants will be muted upon entering the meeting. To speak, click raise your hand indicator, and you'll be called on by the host of the meeting during the public comment section. Please find the information using the link above, the one I just spelled out. Members of the public who wish to view the meeting but are not participating can view a live stream on the City of Norwalk YouTube channel. This stream is delayed by approximately 20 seconds. Please find the information using the link above. The meeting recording and minutes will be posted on the City of Norwalk website within 7 days after the meeting. Members of the public who wish to provide public comment are encouraged to submit those via email in advance of the meeting. For those comments to be read into the record, they should be submitted at least 4 hours in advance to Tammy Maldonado at norwalkct.org. And I'm going to, at this time, call the meeting to order. We did a quick head count, so I'm going to count that as the roll call. The roll call is complete. And now we move to the public hearing sessions. The first up is 22-0120-03, 22 Lowndes Avenue, LLC. Mr. Secretary.
I don't know if I have all the paperwork here in front of me, but I will read what I have. Variance to allow decrease in minimum lot width required for proposed Lot A in C residence zone, property located at 22.5 Lowndes Avenue.
I think that we have a ton of paperwork, but as we go into the presentation by the applicant, I think we'll get caught up.
Okay.
This applicant plans to withdraw.
That didn't come across clearly. Who was speaking?
I'm sorry, it's Tammy. This applicant plans to withdraw.
All right. That's not within the chairman's preview to allow that, but I can put it up to a vote. and I recommend that we do allow it. All in favor of allowing the withdrawal?
Aye.
Aye.
Aye. Danielle is an aye. Tom? All not in favor of withdrawal? Just say not in favor. Okay. Marilyn, are you in favor or not in favor?
I'm in favor of withdrawal.
Okay, excellent.
The attorney, Chris Russo, is here. Chris, did you need to say something?
No, Chair Chris Russo with Russo and Rizzio LLC. I'm just on to see the that the withdrawal was approved. So that's it. Thank you.
All right.
Thanks for your time.
Sure, it's approved, even though I didn't hear from Tom, but 4 out of 5 completes it. Tom, are you still on, by the way?
Oh, yeah, by a show of hand, I affirmed it. I'm sorry.
Okay.
Count me in.
I count you in.
Thank you.
So we have all 5 members that approved the withdrawal. Next item, 220217-01, 289 Realty Associates LLC. Mr. Secretary.
Okay, appeal of ZEO determination of use as a motel versus multifamily residence. In the alternative, variance for residential density, 40 unit existing and proposed, 11 units allowed, and recreation area, 0 square feet, existing and proposed, 200 square feet per unit required, and variance for required parking, 41 plus or minus spaces existing and proposed, 52 spaces required in business number 2 zone, property located at 289 Main Avenue.
Okay, before we get going on this, I want to lay down a couple of principles. We talked about it last time briefly. When we have the case of an appeal of the zoning enforcement officer, any action that that officer takes, we have to hear the appeal before we do anything else. And then we have to approve it or disapprove it. Now, that means you can't mix the argument for variances in with the argument for approval or disapproval of the appeal. There's a reason for it. There's a real good reason. I don't want to take too long talking about it, but that's the rule. So if we have an attorney speaking for the client tonight, remember that you've got to follow that rule. And let's not move into the variances before we deal with the appeal itself. All set?
So I want to interject because I was remiss. Attorney Suchi is representing another item, and she actually wanted to ask for a continuation of that item before she begins her presentation for this item, if that is okay with the board.
Yeah, remind me, which one?
For 21 Sable.
Okay, item C, 2203-1701, property at 21 Sable. They want to withdraw or just postpone for 1 month.
Correct, not withdraw, postpone.
So to approve that, I'll put it up for a vote. All in favor of postponing the 21 Sable application, say aye.
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 Any disapproving, say nay. Any not voting? All right, 5 have approved. It is postponed for 1 month.
Thank you.
Thank you. So back to 22021701, 289 Realty Associates LLC.
Thank you, Mr. Chairman. For the record, my name is Liz Suchi. I'm a partner at Carmody, Torrance, Sandeck, and Hennessy. Our office is 1055 Washington Boulevard in Stamford. Also present this evening is Robert Yaffa and David Wagman. They are principals and the applicant and property owner, 289 Realty Associates LLC, owner of the property at 289 Main Avenue. Just a couple of matters of housekeeping. Before I start, I'd like to welcome new board member Danielle Sanchik. I hope your tenure on the ZBA is enjoyable, and I look forward to appearing before you in upcoming meetings. So thank you for your time in advance of your time to be served on the ZBA. To recap, and for the benefit of Commissioner Sanchik, neighbors were notified of this hearing. The hearing was originally scheduled for February 17th. Neighbors were notified on February 3rd via certified mail return receipt requested, and those green cards were returned to staff. The hearing was continued from that opened hearing date to today. As I mentioned before, the applicant is 289 Realty Associates LLC. It's owned the property at that address since 2005. It is across the street from the Miss Laura Raymond homes. It's directly north of the Citgo station. Tammy, if there's an opportunity to screen share a photo, that'd be helpful. If not, that's fine. It is also to the south of a mixed-use 3-story, 4-story structure that has residential on upper stores with commercial retail on the first floor, and is directly to the east of the Metro North Danbury branch railroad tracks to the west. The district block and lot is 54712. The property is just about 0.42 of an acre. It's located in the business number 2 zone, and it is improved with a 3-story structure. There is on-grade parking underneath the structure, approximately 41 spaces, as well as some on-grade uncovered spaces to the rear of the property adjacent to the railroad tracks. The building was constructed in 1977. The owners also lease land and have leased land from the Department of Transportation for parking and landscaping along the rear of the property, and that lease remains in force and effect. For more than 35 years, this structure has been an apartment building with 40 units, 41 plus or minus parking spaces underneath the building. I've lived and worked in Norwalk, as I said at the meeting last month, for nearly 30 years, and for all the time that I've driven by this property on the way to work, I've known it as nothing else than an apartment building. My clients purchased the property in 2005 with the understanding that it was an apartment building based upon the records that it reviewed at the time of its purchase. And all of those records that I was able to uncover have been provided to you and are part of the application for the appeal, which was submitted in early January. I've also submitted to Ms. Maldonado, per your request, a summary of the documents that were included in the appeal that was submitted to you, so that you have a more shortened version of what all those documents mean. The reason this is before you is that in 2021, this past fall, an unrelated party went to the zoning department seeking to obtain an updated certificate of zoning compliance. And it was determined at that point that that zoning compliance update could not be issued because the zoning office had a 2005 updated zoning certificate that identified the property as a motel. Despite the fact that on that updated zoning certificate, there is reference to a 1983 variance application, which is important. I'll get to that in just a minute. So my clients have submitted this appeal pursuant to section 118.14A1 of the regulations to contest the appropriateness of the determination by staff on December 23rd, 2021, that it could not issue an updated certificate of zoning compliance because this structure is identified as a motel and not as a multifamily residential structure, which it's been for more than 35 years. Whether you uphold the appeal, or if you do not uphold the appeal and grant variances sought, in the alternative, the existing conditions will remain today as they have been. There's no new construction, there's no addition, there's no change in parking, there's no change to the number of units, no change in the composition of units. There are 38 units that are 2 rooms, 2 units that are 3 rooms. All of that will remain the same. But to deny both and to require this be used as a motel would be disastrous and impact my clients in ways that we can't really even imagine right now, not to mention the likelihood of having to displace and find new locations for many of the tenants who have lived there for some time. As Chairman Conroy indicated at the outset, the standards for an appeal and the standards for variances are very different. The standard for an appeal is that we have to demonstrate to you that the determination by staff was in error. And in support of this position, if you've read the documents that were submitted and gone through them, we believe that we have sustained that burden, that the documents submitted herewith clearly demonstrate that this has been an apartment building since 1983 or thereabout, despite the fact that it was originally constructed as a motel in 1977. First of all, the 1983 variance application related to the use of, related to the creation of kitchens in all of the units. And that variance application itself identified this as a multifamily dwelling, not a motel. It was identified and discussed in the minutes of that hearing in 1983, that this was an apartment building and not a motel. And even one member of the ZBA went as far as to say, we don't need a motel here. I understand that there was a staff memo, but the board's resolution in 1983 and the certificate of variance, which was recorded on the land records, and which is something that my clients reviewed upon the purchase of the property, also identified this structure as an apartment. I spoke to Urban Mulvihill, one of the board members who reviewed and decided on that variance application in 1983, in which it was recognized as an apartment. Mr. Mulvihill did not remember the specifics of the discussion or the application, but indicated that he hoped that his prior board's findings and decision would be respected by this board, just as this board would expect its decisions and findings to be respected in the future. The next thing that we looked at and we provided as part of the application before you, the appeal before you, were the assessor's records. In 1972, the assessor's records identify the property as a motel, which is not unusual, since the 1977 approvals would have been then reduced to writing on the 1972 tax cards, and that's exactly what's before you. The current assessor's records, however, and the 1983 assessor's records both identify this structure as a 40-unit apartment, and they even go as far as identifying how many rooms were in each unit, the 38 two-room units apartments and the 2 3-room apartments. Building department, the initial building department file in 1977 clearly shows this as a motel. However, in 1998 and then in 2021, building permits reference work to apartments, not motel units, and identify the structure as an existing apartment. The use is classified as R1, which is multifamily, and not R2, which would be motel or hotel. The fire department has inspected existing apartments within the building in 2018 and 2019, specifically apartments 8, 23, and 29. The health department has tenement registrations for this as an apartment since at least 2014. And in 2019, my clients commenced a tax appeal to challenge the assessment of this property. And in response to interrogatories number 7 and 14, as well as to requests for production, they identified this structure as a 40-unit apartment. In addition, an appraisal was even submitted to the law department as part of the appeal, which identified the use as a 40-unit apartment as well. The law department never questioned nor contested that specific use. Lastly, in February of 2021, the zoning department issued a zoning permit for renovations to apartment number 28, followed by a building permit which was issued later that year and a certificate of occupancy. It was not identified as motel unit 28, but apartment unit 28. So I submit to you that there is ample information in the records of both the zoning department, building department, the fire department, health department, assessor, and the law department that this structure has been an apartment building with 40 units since at least 1983. My client and its attorneys and the title company evaluated all of the documentation that was available to it from these different departments when it purchased the property and relied upon those documents when it made the purchase, including the ZBA application of 1983 and the minutes from that meeting, which have also been provided to you as part of this appeal. A reasonable application of the doctrine of municipal estoppel should bar the requirement that this structure be reverted back to a motel based solely on a 2005 permit, which mentioned the 1983 variance and is also supplemented by all the other information that we provided in connection with this appeal. To require it to be converted back to a motel and negate all of these prior approvals, reviews, and analyses would result in a substantial loss and displacement of many of the 40 tenants. I think there is substantial evidence from the city files that document the use as a 40-unit apartment, and I respectfully request that you uphold the appeal of 289 Realty Associates in connection with this matter. We are happy to answer any questions you may have. Mr. Yaffa and Mr. Wegman are on the line, and we would be delighted if you have questions, we would be happy to answer them. So that concludes the presentation at this point of the appeal of the December 2021 determination by staff.
So we're dealing only with the appeal, not any of the discussion of variances. And with that, have the board members any questions about the appeal? I mean, I have one, but I'm going to hold mine off until I hear from you guys.
I have a strange question. I obviously, like Ms. Sachi, have driven past this building literally for the last 35 years. Has there ever been a permit requested for a motel sign on the building?
That's an excellent question, Mr. Levy, and my examination and inquiries of the building department for sign permits revealed there was never a sign permit requested or issued for a motel at this location.
Thank you.
Hi, it's Tom Farkas. Can I speak for a second?
Go ahead.
Yeah, I'm kind of I'm on the same position as I was when I first heard the argument. And somewhere in that black hole between maybe 1977 and 1983, it became a fuzzy building. It seemed like it morphed from a motel to a place where maybe somebody, this is conjecture, somebody said, you know, if we put some hot plates in here, we made it like an efficiency, we could kind of turn it slowly and turn it from a hotel into an apartment building. And it seemed like that kind of became the thought, either overtly or otherwise. But I've read the same documents, and it seems like a number of different agencies have sort of like tacitly or other than that approved it as an apartment dwelling. And I, you know, I've read what she's presenting, what she's presenting. I'm reading that also. So, and I understand variance is a whole different question, but it seems that there's reasonable doubt here that, you know, that this is kind of looking like a duck and walking like a duck. It's hard to negate what it is now. And I think it's been approved along the way. It's my 2 cents. It's my sense of it.
Ms. Suchi, may I just ask a question? Do all the units have kitchen or kitchenettes?
All of the units have, all of the units have kitchens. They're fully functioning apartments, either 2-room apartments with full kitchen or 3-room, or there are 2 apartment units that have 3 units. They all do. And that was also part of the variance in 1983 to allow each and every unit to have a kitchen. And Commissioner Farkas, in answer to your question, that's where we all are struggling with, from 1977 when it was initially built to 1983, when the variance application came in and it was described as an apartment and discussed as an apartment. I don't know how that happened. My clients didn't purchase the property for another 20 years, but they're left with this type of history from all different departments. And I recognize that they're different departments and the zoning department has its own files and its own requirements. But I think your characterization is right. If it walks like a duck, it sounds like a duck, it's probably a duck. And this has been an apartment since 1983.
I have a question.
Sure, go ahead.
I think like it's definitely seems like it's been used as an apartment pretty much its entire life. But I mean, switching from a R1 to an R2 or a motel to a multifamily should generally go through a change in use through the zoning department, right?
Yes.
Is that the correct process? And it seems like the variance as it reads is clearly looking to just allow for extra kitchens in all of the motel rooms and not a change in use. Is that?
I think that's certainly one interpretation of what took place. However, even in the variance resolution and the certificate that got recorded, it identified this structure as an apartment building. At the very end of the certificate, in the whereas clause and also in the commission's resolution, and throughout the meeting minutes, it was described as an apartment. And the problem really is what happened between 1978 and 1983. That was not of my client's doing. They didn't create the problem. They just purchased what they thought was an apartment. Probably after the 1983 variance, there should have been another document issued to clarify the use as an apartment, but it was never done. It just moved forward and has been used as an apartment, taxed as an apartment, inspected as an apartment, and even, as I said before, characterized as an apartment in connection with a tax appeal.
At some point, we need to hear from the zoning enforcement officer, but before we do, I just want to tell you where I'm having some difficulty. They were bouncing around apartment versus motel in the 83 application. And so when the board's discussing it, several members seem to talk about it as though, this is obviously an apartment house. But at the same time, they were saying, but if we approve it as a motel use, then we approve the kitchenettes and the particular items that that owner at that time wanted were more easily approved if it was considered a motel. And I was struck that maybe I'm missing some of the paperwork. I was struck that it seemed to have been approved as a motel even then, even though they discussed it as being obviously an apartment. So it's kind of like they wanted it both ways. And that's the problem I'm having. Maybe the zoning enforcement officer had the same problem. I don't know. Let's hear from zoning enforcement officer.
Thank you. So I plan to I'll share my screen and I'm going to work through this very briefly for the documentation that I have in the zoning office. So to be clear, I have no purview over other departments and what their determinations are. I can only base my decisions upon what historical information we have in our zoning files. Okay, so can everybody see my screen?
Yes.
Almost. Can you enlarge it just a little bit because it's tiny for me? Good.
Better?
Thanks.
I think
Yeah.
it's tiny for you. I need a magnifying glass.
Okay, I'll go over it. So
Thank
this is the original certificate of zoning compliance issued post-construction. And it states it's hotel. This was 1978. Subsequently, the application was made for variance requesting to allow cooking facilities in all the units, all 40 units. So what was sought was a variance of the definition for hotel, which restricted the number of units with allowed cooking facilities. I agree that the minutes indicate there was much discussion as living units. However, the determination at that time, and absolutely should have been addressed back in 1983, but they didn't say, come back and ask us for a use change. They said, okay, we'll grant you a variance to allow each unit to have the cooking facilities. So this staff memo kind of details the history prior to 1983, and the zoning staff at that time noted that there was an identity crisis, and looking to legalize the situation, they thought the path of least resistance was to seek a variance of the definition of hotel for the cooking facilities. Okay, so that's what this document says. Next, have a copy of the certificate of variance that was granted in 1983. It says, for James E. Rosenkrantz, for a variance of section 118-100 definition of hotel to allow the continued use of cooking facilities in more than 10% of, and then he puts in quotes, living units, premises located at, and then states the property information. Then it says, whereas the evidence deducted at 2 hearings before this board indicates the city of Norwalk gave zoning approval for plans for a project that included kitchens, and whereas it was only several months thereafter that the zoning regulations of the city were changed to limit number of kitchens, and whereas a result, a CO was issued, which contained a restriction that premises contain no kitchens, that restricted, which restriction was not justified at the time, whereas that situation has now only come to this board to be rectified, I move that we grant a variance of section 118-100, which again is definitions, to permit cooking facilities in all of, and this is where they say apartments, rather than limiting such cooking facilities to no more than 10%. So finally, my determination was made in 2005. Someone sought an updated certificate of zoning compliance, not a permit. Ms. Suchi said it was a 2005 permit. However, when people are seeking updated certificate of zoning compliance, it's typically almost universally to determine that the use is legal in order to either refinance or sell the property. And at that time, James Bradley, who was the zoning inspector, stated it was a 40-unit motel with cooking facilities and all unit per that variance. Then finally, I don't have an exhibit for this, but it's in Ms. Suchi's packet. And there's a copy of Ms. Suchi referenced a 2021 zoning permit. However, we did not issue a permit. We issued what is called a sign off, which basically lets building know the building department know that zoning is not requiring a full permit, and subsequently no certificate of zoning compliance is required, which is required if you issue a zoning permit. You have any questions?
Way back in 85, would it have other requirements if it were an apartment rather than a hotel motel?
Right. So that, yeah, exactly. So that's the crux. So when probably the developers in 1978, they couldn't get the same number of units as residential use. The residential use is allowed, but they probably couldn't meet the metrics like they can't today. So I think probably it somehow evolved or manifested into a different use, but was not, legally permitted per zoning department.
Yeah, that was my take too. Dave,
I
do the
don't-
board members have questions for Tammy? So I just want to point out, just before you do your questions, I just want to point out, one of the things we have to figure out is if Tammy had a reasonable, as a zoning enforcement officer, Tammy had a reasonable belief that this was a hotel motel or not. Go ahead with your questions.
I think the one question I have, Tammy, if you can answer it, is what's the plus or the minus for being noted as one or the other in this case? What do you see would happen if it gets actually officially noted now as a motel, or how does it play out?
So I don't want to go into the variance part of it, but if
Don't go into
variance,
variances.
yeah. So there is there's an alternative to the appeal.
Yeah, there are alternatives that the applicant can follow should we uphold the zoning enforcement officer. And that should be a separate decision from anything that we might grant further down the line. Somebody says, oh yeah, I really think that's an apartment building. And then what variance is required and what might we pass, what we might not pass.
Right.
But
Right.
at the same time, we can't go into that right now. We have to stick with did Tammy act reasonably saying this was a hotel motel?
Based upon the information I have as zoning officer.
Further questions?
May I be heard at some point, Mr. Chairman?
No. I want to get this vote taken as to either uphold or not uphold the appeal.
Well, there are comments made by staff and there are representations made, and I'd like to address some of those. So when the appropriate time is, please let me know.
Yeah, I think
Are you
should.
moving into the variance arguments?
No, she has the
Well, no.
opportunity to.
No, you cannot.
Yeah, no, Liz gets an opportunity to rebut.
I do.
Well,
Yes.
rebutting what you had to say about your belief and then the documents you showed us is fine. Moving toward, to really think it's an apartment house argument does not work right now. It's whether or not you had a reasonable belief that it was a hotel motel based on the documents that were in the zoning files. with that, yes, you can rebut.
I just would like to know when. I don't want to take it.
No,
I don't-
that's good. That's good. I just didn't want to veer off into the, oh, it's really an apartment house.
Well, that's the crux of the appeal, that it is. And what I'd like to say is that while the certificate that Ms. Maldonado mentioned, which is part of the record, I don't think that you can disregard the fact that it is that this structure was identified as an apartment, not once, but twice. Moreover, if you look on page 3 of the meeting minutes from July 7th, which were supplied in executive session, the board went to great lengths to talk about what this use was. And one of the members, Ms. Unger, stated, quote, "My feeling is that we talk all the time about needing apartments in this city for middle income people. I would assume from the location it is for working people who need apartments. We don't need a motel here. There are 40 units and it would be a hardship on the people living there to tear out the kitchens and make it a motel. I would like to see it stay the way it is." Other members of the board agreed, including Mr. Kellogg. I agree on this building. And then next page of the meeting minutes, at the end, as I mentioned before, in the commission, in that board's resolution, it said, "I move that we grant a variance of section 118-100 to permit cooking facilities in all of the apartments rather than limiting such facilities to more than 10% of the apartments." So I would just like to state that because it is evidence that the board in 1983 determined that this was an apartment building and not a motel. Moreover, in 2005, when Mr. Bradley issued the certificate of zoning compliance, I suspect there was no inspection at that time. And I don't know why there would not have been a further review by Mr. Bradley of the 1983 application for variance and the meeting minutes to clarify that it was not considered a motel at that time. Having said that, the property has been used in this way ever since 1983. And as it relates to residential density, which was just brought up, that requirement became part of the business number 2 zone in 1988, 5 years after the variance application was granted with respect to the kitchen facilities. So residential density would not have been an issue at that time. I think the meeting minutes, all of the different documentation that was provided that by me militates toward granting the appeal, as these are all indicia of what this property was. And I think this information was available to the staff, that it could have been reviewed and taken into consideration, which we asked that it would be, to make the determination that, yes, this is an apartment and not a motel. This goes to Mr. Levy's comment. There was never even a sign put up on this building that it was a motel. I don't know what happened between 1977, between the time Mr. Rosencrantz and then Mr. DeVito owned it and operated it, but it clearly has never been that use. And to now say some 35 years later, or 30 years later, that this has to be a motel because of a notation on a 2005 certificate of zoning compliance, and to ignore the fact that the zoning department did issue a sign off for repairs to an apartment and not a motel unit, I think is a draconian measure for this, and a draconian action for this board to take.
Well, thank you. I think it boiled down on whether or not the zoning enforcement officer had a reasonable belief that it remained a hotel motel. And if we search the record for a change of use, we don't find one. And if we look at everything said in that meeting instead of some of the things said in the meeting, we find the board confused as to exactly what the use was. And there was some obvious recognition that the applicant would get more of what the applicant wanted if it remained a hotel motel on the records. Even though they think,
At this point in time, was there a
well,
violation notice ever issued to this?
you know what? I'm going to ask that the person running the show mute your mic for a second. Thanks. All right, so here we are with them talking to each other. Some of them saying it really is an apartment building. It looks and smells and tastes like an apartment building, but the applicant is better served if we still call it a hotel motel. And that was the outcome of the meeting. So they left it as a hotel motel. There was no change of use. Going down the line, other people in the zoning department then kept that going. Whether it should have or should not have is a question that should be raised at this point in time, and that would then go to the variance arguments that come later. But whether or not Tammy had a reasonable belief that was a motel hotel, I think anybody in zoning would have a reasonable belief, in my opinion, not what the other 4 members may say, as a reasonable belief that in fact that had never been a change of use, and it remained that, and they got the benefits of that. You can turn Liz's mic back on. Thanks.
Well, toward that end, Mr. Chairman, my clients have also relied on all of the departmental reviews, approvals, and sign-offs that have been undertaken, not only during their ownership, but in prior ownership. So the doctrine of municipal estoppel should be given consideration here, that you just can't now say, after all the time that's elapsed, including a tax appeal that identified this property to your law department as an apartment, that everything else that transpired has no meaning. I think the totality of all of the documentation before you, between approvals, inspections, and other documents submitted in connection with this appeal, should be given just as much consideration, if not more, than a 2005 certificate of zoning compliance upon which the staff relied, and which included the ZBA application 1983 and made reference to that. They've used this property in their ownership as an apartment. It has been that way. That's how they acquired it. And to now say that everything that took place over the course of 35 years is insignificant and has no bearing, I think is improper.
Liz, I think you're making a case one direction. So that direction is that this apartment always has been and you don't quite know when it changed from being a hotel motel. What I'm saying is that as long as it benefited the owner, and what the owner was asking for variances, hotel motel benefited the owner most, and things don't go with the owner, they go with the property. So it benefited the owner to keep it as a hotel motel, and that ran with the property. That stayed with the property records. Should anybody at any time decide that it really was an apartment building and it should not be kept in the records as a hotel motel, then they should have asked to change the use. That did not happen. So I don't know that a zoning officer looking at this record is going to see that, oh, really, it's an apartment building. You can make a case that today the function of it is an apartment building. But I don't see that is a clear outcome, given all the zoning record. Anyway, there's other things you can do. There's other alternatives. Should we uphold the appeal? I don't think Tammy acted unreasonably by saying that's what it is in the zoning record.
I don't know then how do you square that with the sign off by the zoning department to improvements to one of the apartment units, unit number 28. How does that square? There was a decision rendered by another member of the staff that this was an apartment and there was improvements made to an apartment unit. So there was a recognition even in that department, and then again in the building department, and again with the CO, that there were apartments there, not motel units.
Yeah, but I've also seen people refer to motel units as apartments. So particularly if they were efficiencies, and that really clouds the issue all to death. It's very difficult to separate it all.
However, that wording is not on any of the documents since 1983. It's been identified as apartments, as I indicated, and as the documents reveal, on all inspections, subsequent permits, and all of the other documents that we've submitted from all the other different departments, whether it's the health department, the fire department, the tax records, all of these other indicia of apartment are indicated on those records from other departments. So it's there, and that's part of the problem, that other departments recognize what this is and what it has been. And it's just the zoning department that says, based on a 2005 certificate of zoning compliance, it's not. And I just think that's abundantly unfair to my client who has owned and used this property as an apartment. As Mr. Levy said, I've driven down here for 30 years. I'm sure all of you have driven by and have never once stopped to think that can't be an apartment. It must be something else. It looks like it. It acts like it. It functions like it. And there are 40 tenants there. who have leases, who have been there, and who use that. That's their home. It's not a transient building where folks come in for a week and go.
Well, I do think that if we uphold the zoning enforcement officer's decision, that we don't have to throw everybody out of the housing units that they're in. That's not really necessary at all. And I think you can update the zoning records as is to its true use, and we can look at how well it fits the requirements of an apartment house. True?
Well, that's the next phase of your evaluation. You could
Yeah.
also update the records today to make the determination that this is if you want, a non-conforming use, or it's a pre-existing apartment building based upon the 1983 variance and all the other documents, and require my client to obtain an updated and corrected certificate of zoning compliance or new zoning permit, and leave
Yeah.
the status quo. Because in the final analysis, it's not going to change. The building won't change. There's nothing being added to it. The units will remain as they are. The parking exists as it is. And that may be the way to keep the record clear moving forward, that an updated certificate of zoning compliance based upon upholding my client's appeal be issued.
And saying that it's not conforming. Here's the problem I'm having with this. Because it probably seems fairest to you to call it an apartment house, doesn't mean that the zoning enforcement officer's judgment was flawed. It doesn't mean that at all. And the zoning enforcement officer doesn't have to run around and look at every other department's notations. These things that happen in zoning are pertinent to zoning. Anyway, so I think we're at the point where we need to take a vote. And I think the next phase would be, that's why I want to get the vote done, is to hear your arguments about variances. So depending on how the vote turns out.
I'd like to weigh in with one other comment. I've worked in Lower Fairfield County since 1977, both for another firm and on my own. When I first came to the area, one of the things that I learned almost immediately was that Norwalk was very loosey-goosey, that you could almost get away with anything. And I think my time on the ZBA has proven that to me, that permits have been issued, work was done without permits, buildings were built larger than they should have been. And this all occurred under prior administration of ZBA and building. And this situation does not surprise me in the least. And I think we need to take the attitude that was prevalent in Norwalk at that time, the mid-70s into the mid-80s, and take that into consideration as we weigh in on this issue.
Okay.
I just have
Any,
one thing to say.
Tom, you have a point you want to make?
Yeah, who dropped the dime on this? What I want to know is, there's a third party that brought an issue up that got this whole ball rolling, right? So without disclosing that person, what was the issue? Was it too close to the street? Is that what the problem was?
I don't know.
What was the mouse that roared? I guess that's what I want to know. Why now? Why did this come up?
What had happened was an unrelated third party who was interested in the property approached the zoning staff to obtain an updated certificate of zoning compliance. They had no ownership right, they had no ownership interest, they had no authority to do so. Had they not done this, we would not be here. This building would be moving along and the tenants would exist and the building would be the apartment that it is, and no one would have thought anything else as they drove by or looked at it. Perhaps it might have come up at some point in the future, but it hasn't come up since my client's purchase in 2005. And there were never any notices of violation sent to them. It came up because an unrelated party made an inquiry and asked the staff to issue a document.
Because I noticed a note from, I guess, a neighboring business saying that his sight line is affected because of the abutment of this building, unless I read that wrong.
But the building is not going to go away. I
Yeah,
No,
don't-
it's not. And you know, the only thing the only indication I see that this is a hotel is built so damn close to the road. It almost seems like in the old days that you put your hotel right close to the road, you're easy in and out. And that's when I go by that. I questioned it. I said, hotel or apartment building, you know, architecturally, it's not going to win any prizes. But I figured that maybe because it was so discreet looking, that it was an apartment building, sight unseen, with no information.
Well, it seems that the use now is that. So anyway, if it would be nice within the realm of zoning that if people change a use, they ask for the change of use and they just don't do it all on their own. With that in mind, I think the CEO is reasonable in her belief that no change of use had ever been made. I also think it's reasonable to apply for a non-conforming apartment house change of use once this thing is resolved as an appeal.
Would agree with that. But I'd like to see, I mean, not to butt in, sorry. It's been an apartment building and the idea of changing something that I think serves a very good purpose and changing the status or, you know, I think would hurt a lot of people, but to everyone's point, I mean, I think that it needs to be clarified, you know, on paper as to what it is, as opposed to, you know, having differences of opinions and it going back to 1983. So it should be clarified, but I'd like to, personally, I'd like to see that building remain the way it is. It's functioning and I think it functions for people that really need that housing. And it's been there, it hasn't hurt anybody. And the building is not going to go away. And they probably don't need a motel there. But it's people's homes. And I think that it's no one's fault. It's no one's fault at this, at our meeting here, that this happened starting back in 1983. But I think it needs to at
Well,
least be.
I agree with you, but don't agree with you. There is a process in all the things that we do, and that process is not to ignore CEO judgments and decide the CEO is by nature wrong. It seems in this case, there's an argument to be made that this is an apartment house. It also seems that the benefits accrued to calling it a motel hotel. And so it stayed that way, so that the benefits accrued. And so you really can't have it both ways. What needs to happen is a change of use. And we can move on to that next. But in my view, the zoning enforcement officer did not make an error and made a reasonable judgment. And no, we're not throwing people out on the street. Anybody else? So let's go to a vote as to whether or not we uphold the appeal. Is there a motion to uphold the appeal? Marilyn?
Well, if you uphold the appeal, you'll be endorsing that I was in error.
That's
So
right.
Okay, I just wanted to
right.
clarify.
I'm not going to vote for it myself. I'm going to vote against upholding the appeal. But somebody needs to make a motion one way or the other. I don't care how the motion is put together, but make a motion.
I'll vote to uphold the appeal.
Okay. So is there a second?
Yes, I'm going to say.
Marilyn?
Yes.
Tom made the motion, Marilyn the second. So all in favor of upholding the appeal, let's just go slow here. I'll go one by one. Marilyn, are you in favor of upholding the appeal?
Yes, aye.
Tom, are you in favor of upholding the appeal?
Yes, I am.
Okay, I am not. Lee, are you in favor of upholding the appeal?
Yes, I am.
Okay. Danielle, are you in favor of upholding the appeal?
I'm not.
Okay. Well, 3 in favor and 2 against. The item fails. 4 needed to make the item pass as per statute. So let's move on to the next piece of this. The next piece will be, I think, in Liz's court, and she's going to ask us for 1 or more variances. Go ahead, Liz.
Correct, thank you. As I mentioned at the outset of this presentation, regardless of whether you uphold the appeal, which you have not, or you decide to grant variances that we have suggested are necessary in order to keep this as an existing apartment building, the structure will not change in the least. The size, the height, the number of units, the parking, configuration, where the parking exists, open space, the lease with the state in the rear, all of these conditions remain unchanged and will continue to remain unchanged. What has now happened is you are requiring us, by virtue of denying the appeal, to seek variances for recreation area. Since none exists right now, we would need to obtain a variance for all of recreation area. Parking, 41 spaces exist on the site, and under current regulations, 52 would be required, and residential density, which I mentioned earlier became effective in 1988, not at the time that this structure was constructed, so there was no residential density requirement.
That's an important point. Thank you.
So as you are aware from your past dealings with applicants more frequently on variances than appeals, you may vary the regulations upon the demonstration of practical difficulties or unnecessary hardships created by the application of the regulations to a particular piece of property or use. Variances may be granted when the request is in harmony with the general purpose of the regulations and so that it achieves substantial justice. And I emphasize that last phrase because I think in this instance, that is the gravamen of this determination by you, to achieve substantial justice for a property owner that has owned the property since 2005 and has paid taxes on it since 2005 as an apartment building and has maintained it and had it occupied by tenants since that time. They did not create the situation that is before you, so these are not self-created hardships. They are hardships that have been created by virtue of the conversion of this structure from a motel in 1977 to apartments in post-1983, recognized, as I said before, by the ZBA of that use. Multifamily residential is allowed in the business number 2 zone. There's a condominium complex of 29 units directly across the street. Senior residence, the Miss Laura Raymond Homes is across the street. There is a mixed use complex to the north that has approximately 15 apartments above residential, and the Metro North tracks are to the west with the Citgo station to the south. So certainly the use is not only permitted in the business number 2, but compatible with all of the other uses that exist around it. Granting the variance is sought would maintain this property as a 40-unit apartment consistent with the neighborhood and consistent with its past history, and would be a just result. It would be extremely difficult, if not impossible, for the applicant to comply with all of the current requirements relative to parking, density, and recreation area without substantial and extensive changes to the property and its sizable costs and expense. There simply is no more room to create any more parking spaces. There isn't any in the rear. If you've traveled to the site, you will see that the parking spaces almost directly abut the fencing in the rear. And those 2 last parking spaces closest to the Metro North Railroad tracks are on Metro North land for which we have a lease. There is no available land, as I said, to create parking. There's no space outside to create recreation area, either on grade or within the building. And we've never had any issues, violations, or complaints regarding parking with respect to the apartments. So it would be an unnecessary hardship and overwhelming burden to change, to require us to somehow reconfigure the parking that exists today to create any more. The parking simply can't be reconfigured under the building. If you've driven there or seen the photographs that I provided to staff, the spaces exist, 8.5 by 19. There's no way to reconfigure. There isn't any additional room that we might be able to get another space or two. The spaces exist. There's no other way to achieve that. There are also practical difficulties and necessary hardships with respect to recreation area. Again, there is no space to create that. The only area that might be available, and it's very small, would be the small strip of grassy area in the back that perhaps my clients could place maybe some benches, but there certainly isn't the 200 square feet of recreation area per unit that would be required. The same is true now for residential density. That is a requirement that came in 1988. Residential density does not allow for 40 units. It allows for somewhere in the area of 11 or 12. So that it would be a substantial burden, a substantial hardship and an unnecessary burden on my client to comply with the requirement of residential density as it applies to this building. So the practical difficulties and unnecessary hardships come from the strict application of the zoning regulations to this multifamily structure years after it was constructed and years after it changed from a motel use to this multifamily use that has existed for nearly 4 decades. And based upon taxes paid as an apartment, fire inspections indicating that it's an apartment, it's clear to me that all of these are additional indicia of it being an apartment. But going back to the variance request, you have to establish a
I want you to
practical.
organize your requests so that I know which one you're working on. So if you want to work on parking first,
We did parking.
yeah.
I just did recreation area. You'd need
Yeah.
8,000 for a 40-unit apartment building. There's not 8,000 square feet of space available. They might be able to, as I said, identify some space in the rear of the building adjacent to the existing fence where there is lawn, put perhaps some benches there to have that considered recreation area.
So if we let you be non-conforming, which seems like we would probably do, then we could require that rear space become available for the tenants.
Become available. And I would, and my clients, I'm certain would accept that kind of condition because that would be going toward your possible approval of a variance for recreation area. And the last one is residential density. That's a function of a calculation of a number of amount of square footage for each unit of the land mass per unit, and you come up with a certain number.
Let me ask a quick question of Tammy. Tammy, was it 1988 that a ratio was determined?
I'm actually not certain. That's what Ms. Suchi cited, and it sounds accurate to me. I didn't.
Right, but it couldn't have been 1978. I mean, that's just too far back.
1988 was when residential density became a requirement in the business 2 zone, 1988.
I'll accept your dating and.
Sounds reasonable.
So it just doesn't seem that anybody could force that at this point in time.
And lastly was, as I said, residential density, how many units could be how many units could be constructed into structure today. 1 unit per, I think it's 1650 of square feet of land mass. So the 40 units would not be able to be constructed today because the site is only less than a half acre. Again, that's a situation that exists. It's a substantial difficulty to comply.
So parking, recreation space.
And residential,
density.
yes.
Are those the 3 things that you're requesting?
Yes, they are.
Lee, you want to make a motion regarding those 3 things?
I'd like to make a motion that we approve the variance requests for parking, recreation, and density for this site at 289 Main Avenue.
Do you want to put the stipulation on it
Yeah.
that the grassy area to the back is to be made available to the tenants for recreation?
I will also add the stipulation that the open space at the west side of the property be equipped with benches and landscaping appropriate for a passive recreational use.
All right, that's fine. Let me ask one question of Liz. I see it as not possible to add any parking. But if there's some changes in ownership of property adjoining, then it might become possible to add some parking. Can we add something, you think your client would live with it, that says that should property become available, that they would attempt to add parking?
Andy, I'd like to comment first. I don't think that is even a possibility, given the gas station and the retail apartment building to the north of it.
No, I agree with you that the current situation is not such that allows it, but should a change of a gas station to a Midas muffler shop or whatever,
Yeah.
Properties do change over time.
Yeah, I don't see it. This property.
I have to I'm sorry, I have to interject.
Okay.
Go ahead.
But we made a motion, but we didn't afford the public the opportunity to make comments.
Okay. I think I didn't notice that we had pending public comments on the appeal.
So if there's anyone who, are you talking about wishing to speak now? Or are you talking about our
No, we haven't,
Or
done-
not?
we haven't, we're in the process of doing this and we can halt the motion and not vote on it. But I think we can structure it and put it together because it is complex. And then the public will know what they're commenting on. And I think the public is due that privilege. But I don't think anybody was trying to address us about the appeal. Am I wrong? Was there somebody that
No,
was?
I'm not talking about, I'm not sure. There are people in the queue. I'm not the Zoom host, so I think there are other attendees here. I'm not sure what they're here for, but if we prompt them to raise their hand, then.
Yeah, we did that. So let's just add that if there's a way to include future editions of parking, we would like the then owner, whoever it may be, to take that into consideration rather than to say that could never happen. Right now, it's not practical and it isn't going to happen immediately. But those would be the motion with the stipulations. And if we have somebody from the public that wants to comment, that's very good. Let's have them do so.
Sure. So there's a few people on. If you'd like to participate on this item, please use the raise your hand feature and we'll bring you over to speak.
Keep me appraised.
We had,
there's-
I'm sorry, go ahead, Michelle.
There's no hands, but if you are dialed in on a phone, press *9 to raise your hand as well. But for the moment, it doesn't look like any hands, but maybe give it just a minute.
While we're waiting for that, we did have 3 letters, 2 from one party and a third letter from a separate party.
Yeah,
With
I've been
comments.
through about 200 sheets of paper. Do you think if you've got those immediately at hand, you could read them, Tammy?
Yes.
So we have no one offering public comment is our understanding at the moment.
Live,
Besides the
that is-
letters that you're going to get.
Correct.
Okay, go ahead.
Okay, so this is a lengthy letter, February 24th. Dear Mrs. Maldonado, thank you for your email notice informing of the March 17th ZBA meeting for 289 Main Avenue. The original canceled meeting of February 17th was to be virtual. Will this be the same? How does one attend? At any rate, as the owner, builder of 295 Main Avenue and previous owner of what was 315, 317, and 319 property preceding our new multi-use building since 1988, my family is very knowledgeable of the history of 289 since 1982. Their building of a motel, he puts in quotes, allowed them to build 6 feet from the front property line. Subsequently, it seems kitchens have been added and usage changed to that of a multifamily building. Whatever knowledge the city had of this, I do not know. The building was purchased by another owner in 2005 and continues as a multifamily. Through the years, there have been and continue to be cars owned by residents of 289 on our property, imposing on residents and customers. Additionally, their building and parking area compose such a major part of their property that its tenants' furniture deliveries and removals cause trucks to service them from our property. Our property is not the only one so abused in the immediate area, and it is critical to fairness and compliance with our laws that this be corrected. Please keep us informed in what ways and by what laws we will be so protected, including planning and zoning's approximate timetable to correct these violations. Further, with the violation of the setback regs by 289, we suffer lack of exposure for our retail tenants. However, we would be much obliged after all these years with strong enforcement of the sensible parking regs. Very truly yours, Louis J. Marino, owner 295 Main Avenue. In addition, James Stewart submitted on February 9th, Officer Maldonado, please be advised concerning 289 Main Avenue. The back parking lot extends 15 feet onto Metro North property, further impacting required parking. Some studio apartments in the building are occupied by families of 5, also impacting residential density. the 289 Realty Associates LLC stakeholders' applications for variances should be denied. I would appreciate the opportunity to speak with you. I can be reached at, and James Stewart provides his phone number. He sent on the same day on February.
Wait, hold on one sec. That letter doesn't seem to recognize that they may have leased parking spaces from Metro North.
Correct. He's just making his own
Okay.
comments.
So that
I'm
they don't
not,
know that
I'm
they
not
did.
talking
They
about
think- I
whether or
think
not-
they're encroaching. Okay, go ahead.
Yeah. And then, so his email from earlier that day, or I'm sorry, later that same day says, the two stakeholders comprising 289 Realty Associates LLC, Robert Yaffa and David Wagman, excuse me, are engaged in self-enrichment. They are both multimillionaires residing in New York State. These variances, I think this is a typo. I think it should say they are applying for are to further enrich themselves. There is no common good for the city of Norwalk or the tenants at 289 Main Avenue. Sincerely, James Stewart. And that concludes the
Those are the letters?
comments received.
Okay, are there any other public comments? Liz, unmute yourself.
Yes,
Do you want to refute anything?
I just want to make two comments. As far as the Marino property to the north, any time that there have been issues raised to my clients or identified as being created on their property, my clients have addressed them and will continue to do so. They too want to be good neighbors and have been good neighbors and will continue to be good neighbors. If issues arise, they certainly have Mr. Yaffa and Mr. Wegman's contact information and can feel free to contact them and have whatever issues be resolved quickly. I might add, though, that one neighbor needs to be a good neighbor to the other, and the Marino property and some of the customers at the liquor store do have a tendency to dispose of their used and empty liquor bottles on our property. So it's a little bit of everything going on, but my clients will be responsive to any comments and questions, concerns, and problems that arise. As far as Mr. Stewart is concerned, he used to be a tenant in the property, is no longer a tenant in the property. And he also shared an additional email to my clients about their application, which the contents of which were so reprehensible that I refused to share it with you in light of just common decency. So there is another, whatever is going on, whatever went on with Mr. Stewart at the property, he's no longer there, and he is misinformed about the use of the rear of the property for parking, since we've already indicated there is a lease with DOT for that purpose.
Yeah. Is that it, Liz?
Yes, Mr. Chairman, that's it.
Okay, thanks. So with the, hopefully we can remember the motion as it was structured. We need a second. I'll second the motion. Lee made the motion and it has 3 elements and 2 stipulations. Need anybody to go back over that, or you all set?
All set.
If you're all
Good.
set, we'll go
Good.
to a vote and vote on the variances that have been requested. I support the variances with the stipulations.
I support the variance and stipulations.
So all in favor, say aye.
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 Am I missing anybody? Anybody a nay? Anybody not voting? Okay, we're fine. So we're unanimous. All 3 variances are granted with the 2 stipulations. And I think we have completed your business, Liz.
Thank you, Mr. Chairman, members of the commission. Appreciate your time and effort this evening.
All right,
Thank you.
Thank
so
you.
long. Marilyn, just a quick note. There are alternatives to just ignoring the zoning code, and we just did that. And those were the alternatives. And so the use as it stands continues. Okay. You sound like a beaten child.
Well, I have one question.
Yes, Tom.
Will this forever go on as being a duopoly here between the hotel and apartment? Or one
No.
day down the road, will we
No,
call it
no.
an apartment?
Now, what they should do is ask for a change of use with the variances that we have, and that it's non-conforming. And then the zoning department should not give them a hard time over that and just put that through.
Got it. Okay.
Yeah, it was
Okay.
weird that they didn't do it in 83.
You know, the game that I thought was being played by former owners, not the current ones, was we're an apartment house, but we want to be called a hotel motel because we don't have enough parking and we want the benefits of being a hotel motel. I thought that was the game being played.
Or they found it advantageous stepping into that, yeah, I mean, I see your point, because there are different rules that ensue different,
They could make it more dense and not get in trouble. And so they played that game. And the board recognized it and they should have put their foot down back then. The ZBA should have said, hell no, you're either an apartment or you're a hotel motel and you're not sort of in a gray ground between the two. Anyway, that's my view. And I'm just one of you. There's 5 of you. You can always overrule me anytime you want. Okay, next up, Mr. Secretary, let me see what's up here. We
MD.
got D, which is H. Shaw, 220317-02, property located at H. Shaw Avenue.
Variance to allow parking within the front yard setback of existing single-family residence in B zone, property located at 8 Shaw Avenue.
Mr. Chairman, ladies and gentlemen of the board, good evening and happy St. Patrick's Day to all of you. I am John L. Vecchiola and my law office is at 7 Benedict Place, Greenwich, Connecticut. And with me this evening is Mr. and Mrs. Charles Bavona. Marilyn Bavona is the applicant and both of them
John,
are
can I interrupt?
Yes.
John, I'm sorry, staff memo. We typically read staff memo before the
Oh, I'm
presentation.
sorry. I'm sorry.
Okay.
I thought that Lee had whatever there was.
That in front of me. So if somebody else would read it, that would be good.
Yeah, I'm not sure I'll do it. Let me find H. Shaw in my records here.
I have a copy of it if you want me to read it.
No, let me see if I can find mine first. I just have a lot of paper. We're not going to be doing this in the future. I think several hundred sheets of paper is not in our interest. Okay, the request, the applicant seeks variance to keep the existing driveway configuration, although it does not provide zoning compliant parking. The background, the single family home was built in 1940. It previously contained an integral 1-car garage that was at some point altered without permits to living space. In 2019, permits were issued for addition of a bathroom, and it was noted on the permit the driveway may need to be altered prior to a certificate of zoning compliance. Let me double check that I'm doing this right. Post-construction zoning inspection confirmed that there was not a compliant parking space and therefore a certificate could not be issued. Analysis and findings. Although the current homeowner was not responsible for the conversion of the former garage, this should still be considered a self-created hardship. There is a possibility of creating a compliant parking space by either restoring the former garage space or installing a new driveway on the other side of the building. Removal of the existing driveway and restoration of landscaping would require the latter option. And the property is located at H. Shaw Avenue, District 5, Block 74, Lot 15. All set?
All set. We do. As stated, with me this evening is Mrs. Bavona and her husband, Charles Bavona, and they are seeking a variance of the existing driveway pursuant to section 118, 1220J. And as cited in the memorandum, this is an older development in the city of Norwalk and can be found on map of section B of Roten Hill, Norwalk, prepared for Chatham Homes Incorporated, 1940. I do have a copy as an exhibit of that map. And if the host would like to share it with the members of the board, if they have not seen it, I think it would be appropriate. I also included in my package GSI maps showing the subject property, lot number 64. And you can see the development in the neighborhood, which probably was developed prior to the present zoning regulations. Well, it's in the first part of it. Keep going down. Keep going. There. You can see that Hilltop Road is now Shaw Avenue, and 64, if you take a look, is approximately right there. And then if you go to the GSI maps, which should follow, if you go up, oops, you go down one and see if it's up there. Okay. Maybe it's
The
at the,
GIS map might be in a separate file. There's two.
okay. Okay. But they would just show the boundaries of the property. And as stated, this house was built in 1940, and some say it was a Sears Roebuck house. The first owner was the applicant's grandfather, Patrick J. Sheridan, and this property has been in the family for the last 82 years. The applicant purchased this property from her cousin, Mary Sperry, and throughout the ownership, the driveway has always been in its present location. And I did include deeds if you'd like to see some of the conveyances, and I also included the Norwalk assessment. Well, there's the GIS map, and then if you go to the next one, and the property is there. Okay. Okay, why are we here this evening? Applicant and her husband applied for a building permit B190817 on August 1st, 2019 to construct a bathroom at the rear of the house. All inspections were completed and passed to include the final inspection. Applicant has been unable to obtain a certificate of occupancy due to supposedly the deficient length of the driveway in accordance with the appropriate sections that we're seeking an appeal for. Unbeknownst, or approximately maybe 29 or 30 years ago, the garage, which was not feasible to put a car in, was converted to family use, which is being used now as a dining room. If the applicant knew that she would not be able to obtain a CFO, she would not have opted for this construction. And I do not see any language in the building permit stating that there is a problem with the driveway. And I included that in my package. If you can find the building permit and the inspection card showing that all inspections have been completed and have passed. Can the host share that if they can find it?
You're looking for the pictures of the survey?
Do the building permit and the building inspection record. I don't see anything in there other than zoning officer must submit zoning compliance to Department of Code Enforcement. That's the only notice that I have that my client would be aware of. We also have discussed this application with two of the neighbors, Claude and Dolores Vigneault, and they have submitted letters to the board. And neither one has any objection. Mr. Vigneault does make a statement in his letter that the topography of the Bavona property is elevated above his, and he would not be agreeable to having a driveway located on his property line. And he's perfectly in agreement that the current driveway should remain in its present location. Mr. Kimball Hersey is the owner of the property across the street, and he's lives in Athens, Georgia. We talked to him on the telephone, and he supplied a letter, and then he has no objection granting the variance, and he would like to see the driveway in its present location. I've also provided 6 photographs of the Bavona property, and if you could bring them up, you can if you bring up the photographs, we can show you what the property looks like, what the driveway looks like in its present location. Here's the front of the house. It's Cape, and you see the driveway to the right. Another view from across the street. And these pictures were taken in October of 2021. Next, there's the driveway. And if you go up next, you can see in some of the pictures, you can see the demarcation between the driveway and Shaw Avenue. I don't know if they're in the next one. Yeah, you can see that. The driveway will allow parking to at least two parking spots and a third with ease. The next photograph, the next 2 photographs is to the side near the Vigneault property, on which there's a fence, and the elevation, the topography is higher than Mr. Vigneault. This is where the memorandum said that a driveway could be relocated. However, there are household, how do we say this, extensions that go into near the fence. I don't know if they're for utilities or they are for hoses or something. What are they for?
Bay window, air conditioning unit, and that outside staircase that goes to the cellar. You couldn't possibly put a car there. There's not enough room.
So that's what Mrs. Bavona is telling me, that there are HVAC equipment there, there are stairways, and that there wouldn't be enough room for parking of a car on that side of the house. And there's a drop off of about 4 feet between that property and Mr. Vigneault's property. So we do have a topographical problem. And this is part of the property that would be impacted.
Do you have a property survey that indicates this?
You have a survey. It was filed with the original documents. There they go. Yeah. They have which shed is out there?
Oh, this here, because it's covered.
Yeah.
They put shed, it's the outside staircase.
Okay.
And it was 40.
And then I also wanted to present photographs of neighborhood properties to show you how the neighborhood was developed. And if you bring those up, I can tell you which numbers they are. There are 6 more photographs of the neighboring properties that I think might be beneficial for you to see. If you go up a little more, I think, yeah. Okay, some of them are, okay. Well, I'll go by numbers. If you go to the top of the presentation there, of the photographs, and I'll tell you which ones they are. Okay, okay.
No.
One more. Up one more. Oh, the first one is One Shaw, and that's the yellow house. Yep.
Yeah,
Go ahead, go down, you're fine. That is number 3 Shaw, Paul and Pamela Langevin.
No,
And that's not Langevin, that's 5 Shaw, excuse me, and that's Marilyn Lopez, and they are renovating the house. And the driveway is, there's going to be a garage there, but the driveway is the same size, approximately the same size as 8 Shaw, the applicant's property. The next photograph is 7 Shaw Avenue, Karen D. Vita. The next photograph is the corner of Scrivener Avenue and Shaw Avenue. And you can see they have 2 driveways, and I don't know if they're compliant with the regulations. And then if you go down one more, that is 1 Shaw Avenue, the home of Thomas A. Wrigley. And the one below that is this 2 Shaw?
Yeah.
Is Matthew Presley. And then there's, following one is 3 Shaw Avenue, and that's Paul and Pamela Langevin. And they do use their garage for living space. Okay, in conclusion, this property was part of a development developed more than 80 years ago, prior to existing building and zoning regulations. This property and its driveway is non-conforming and existed in its present location long before section 118.1220J was amended and took effect in May of 2000. It is clear that granting this variance will not be detrimental to the neighborhood, or will granting this variance change the character of the neighborhood. The driveway will continue to remain in its present location as it has for the last 82 years, and there will be no impact whatsoever with the neighborhood. Thank you.
would board members like to ask any questions of the applicant?
I would just like to know why the applicant was not aware that they had to comply with zoning when they applied for the building permit.
I have Mrs. Bivoni here, and she can answer that question. Go ahead, you want to sit down, Chair?
I didn't know anything. I had called for the town to come out to my property in '93 for a pool. And he said, no, it was an above ground, the kind you can tear down. You know, it's not the kind you build into the ground. And he said, you don't need a permit for that. But he looked up at the neighbor and he said, but that guy didn't get a permit.
That's
when
not
I-
what I'm concerned about, ma'am. I'm asking, when you got your building permit, Did your contractor not make you aware of the zoning requirements?
He was not aware of any zoning requirements when he applied for the permit. We applied for
Did-
two permits.
yeah.
We asked for a permit for the back of the house for a family room.
I understand
And we
that.
said no. So why did they give the permit if they weren't going to give the CO? Why would you do that
No.
to the average person? I don't
Yeah.
know. I have no explanation. I don't know the answer.
You
to that.
have your contractor available to answer a question.
No, I don't. I wasn't given any information from the town myself. I'm the owner of the house. I think they should have contacted me
but
right then and there.
Was your contractor. And he should have, before he got his
He
building
got
permit,
information for the family room.
to ask my question.
I'm answering your question.
I
He got,
haven't,
when we wanted the family room put on the back,
I
they said you might
that.
have a problem with the driveway. So we said, we don't need the family room, we'll just do the bathroom. And then they gave us the permit. That's all that was said.
Your builder had to get a zoning sign off before he could get a building permit. So some information was exchanged. Why don't you have it? My question is asked and answered.
If you look at the building permit that was issued, it says nothing about the driveway being deficient.
That would have been in the zoning review that had to be signed off before the building permit was issued. It's not part of the building permit.
Who I can be honest with you, my client doesn't have it and she doesn't know about it. And if the contractor knew about it, he didn't tell her. Let's put it that way.
Well, I certainly, from my opinion, I can't grant a variance for something that we're lacking information on.
Well, what we could do, continue this.
I don't know if it's appropriate for me to interject, but I have a copy of the zoning
Please.
approval I could share.
Please do.
This is construction of the addition for a full bath. And at the bottom, signed by the applicant, signed by the zoning officer, driveway may have to be altered prior to COZC.
Thank you.
Okay. I can honestly say my client never saw that
Well,
because she would have not gone through with this.
I would also add that I met Ms. Bavona at her property several years ago and discussed this matter with her. In addition, I've met with her in the office since then several times, provided her copies of all this information.
I have no further questions.
I have a question for Tammy.
Yes.
What would be the simplest way without trying to go to the other side of the building to become compliant?
To restore the dining space to garage space. I don't
And
know that that's the simplest.
That
That's,
restoration requires destruction of part of the building, is that correct?
well, it would be a major undertaking, but it wouldn't change the building, the exterior walls. It wouldn't change the structural issues. I mean, I'm not an engineer, but I'm not sure that when I met the contractor there, I posed that question to him, what he thought would be the least expensive alternative. And he said, I should know. And I told him I didn't, so.
Yeah, same question I had. I think everybody not knowing is not appropriate.
That's true.
I also don't think that it's appropriate to create a big mess here. So I'm open to solutions if somebody's got one. We got two architects.
I think the simplest solution would be put in the new driveway. No destruction to existing structure or alteration.
You mean the new driveway on the other side of the house?
Yes,
Yeah, you'd have to do some destruction over there. I think there's an air conditioning unit installed in the ground.
air conditioning unit can be picked up and moved. It's about a half-hour job.
Well, let's say it's a half a day job, but anyway, yeah, that seemingly on the diagram of the property seemingly was a wide enough space for that.
There's 15 feet between the bay window and the property line. More than adequate for the width of a driveway and to park a car.
Yeah, that was my impression. That seems the least expensive way to do it. Turn into the house is not smart.
No,
I think may I interject, John Vecchiola? I think the dimension is 8 feet, not what you're saying.
I just scaled it off of your survey.
He's
And
one
then
of
you
our
would need
architects.
you would need also, sir, you need a retaining wall, and you're going to have an objection from Mr. Vigneault. He does not want it on his side of the property.
Well,
That
that
may
may
not be his choice. Yeah. If it's appropriate, because sometimes you have to look at the landscape and make sure it is appropriate, then I think I agree with that. Maybe the contractor should take a look at it and come in with his costs and recommendation. Maybe we should postpone a decision until next month so that we get the contractor's recommendation
I think
And
that's
cost.
reasonable.
and cost.
but cost has never been one of our considerations.
No, but I think the owner needs to know the cost. I don't need to know it. You
Neither
don't
do I.
need it, but the owner needs to know it.
Fine. I'm
Yeah.
for postponing a decision for a month and we get the contractor to give us cost on the two alternatives.
Okay, so I move that there be a postponement for 1 month. We have any problem with that motion?
No.
Tammy, a month's delay is not a problem? Unmute yourself.
Yeah,
There you
sorry. Yeah, we can move it to you.
Okay, so with that in mind, I don't think we need public input on a postponement. So all in favor of postponement, say aye and raise your hand both, so that way I can figure this out.
Aye.
All right, great, we're all set. You're postponed till next month. In the meantime, you have some homework, and that homework is to get the contractor to take a look at putting the driveway on the other side of the house, what's entailed, and informing the owner and you. All set?
Thank you very much, Mr. Chairman, and have a good evening.
Have a nice evening. Thank you. Let's see who we got next here. I think it is 4 France Street, 220317-03. And Lee, do you have that one or do you need me to get it?
Again, that is in my email, which is in my computer, which I don't have access to.
All right, let me see. I got it. 4 France Street. 220317-03, Alex.
Adam on four.
And variance of side setback, 6 foot required, 0.5 proposed, rear setback 10 required, 0 for deck and 5 foot for exterior wall proposed. And a height 15-foot roof, midpoint maximum 26.1 feet to roof peak proposed. And it cites the sections for detached accessory structure under construction in B residence zone. Variance to allow dwelling unit in same detached accessory structure under construction. However, use variances are expressly prohibited by section 118-340B3. The property is located at 4 France Street, District 1, Block 79, lot 2. So we know what the request is. The request applicant seeks to finish the construction of a detached structure that does not meet rear or side setbacks, encroaches on the neighboring property, and exceeds a allowed height maximum. The proposed use is garage on first floor and dwelling on second floor. The Norwalk zoning regulations expressly prohibit use variances. Dwellings and detached accessory structures are not permitted. Background: this property contains a 6-unit dwelling, existing non-conforming. The property is currently in violation of citation process for work without permits for construction of the detached structure, and the applicant seeks variance to cure this violation. The property and the current property owner was also previously cited by the zoning staff in 2017 for operation of a contractor / commercial business and storage yard. This property has been cited by both zoning and building code enforcement for the work without permits, and currently there is an injunction to prohibit the resumption of this work. The staff analysis and staff findings: this is an entirely self-created hardship. The applicant is a contractor that knows the required process of the application for permits. Had an application been submitted for permit, certainly these compliance problems could have been avoided. While staff is sympathetic to the property owner's tragic family loss, staff cannot identify a rationale for allowing the encroachments, height of structure, or the use as a dwelling to be approved. And we're ready for the applicant to speak.
Cindy Garcia Diego here with Alex at Amatfar. You can explain for them. He would like me to explain for you that, yes, he did know that he needed permits for all of this stuff that he has done there. And in the craze of him losing his eldest son or youngest son, he started this construction just because of the fact that he could not live in his dwelling, which is 171 Danielle Drive in Stamford, due to said loss, and ended up in the hospital with a heart attack. After he came out, he just started to start this construction just to get his mind busy. And once the stop work order hit, he was supposed to stop all work, and it's been cited 3 times since the first stop work order. Either he had stopped work, but people cleaning on the property or whatever, they did find a contractor on the property the last time building and zoning were there. He was winterizing the window, and that became an issue with building and zoning, which I agree. Yet he wants to put in the variance to continue to work and try and fix the situation as it is right now. He's done plan, survey, everything that he's been asked to do thus far. And hopefully he can be heard and understood in this situation. Whoa, I felt that.
Just my phone dropping.
Okay, I thought maybe we had somebody attacking Al.
No, sorry. Taking a laugh.
There's an awful lot of stuff to ignore.
Yes.
And I can't do it. I got to tell you that this is just barking up the wrong tree. Tammy, you have any suggestions for the applicant? Unmute yourself.
I believe he should remove the structure and then seek permits to build a structure that could be compliant. But he could not have the use as a dwelling.
Wouldn't it be smart for him to withdraw his current application and try to craft something that works?
That he's making the variance application to cure. He's in the middle of violation process.
For some reason, you're going in and out. Do you have a noise that's somewhat near you that might be affecting your mic?
No. If I lean closer, does it sound better?
That's better, much better. Yeah.
Okay, so I was saying that the variance is sought to cure the violation. As soon as, if the variance is denied, the violation moves forward and his fines accrue, or they continue to accrue.
I don't know that we can fix that. He needs to fix what he's doing. And so he needs an approved plan with variances that make some sense rather than, oh, geez, I'm going to build it as wide as I want with 0 setbacks and as tall as I want. And that kind of stuff doesn't work.
But there's no hardship for variance because there's a location he could comply with.
What hardship does he have?
No hardship. He could make it compliant. He has space on the property to have another shed. He has one, or he has an outbuilding existing already.
Right.
It's noted on the survey.
It removed as of the 15th with permit.
No, I'm not talking about the shed. I'm talking about the
Oh,
other
okay.
building that's
Oh, the-
listed as an office on the survey.
Yeah, the office.
I would vote against this without thinking about it. It just isn't something I want to vote for. I don't know
think
how
the
anybody else feels.
I think the violations are so egregious that there's no way in the world that I could even consider voting for this request.
Yeah. So I think the smart thing is to withdraw and get your act together and then come back and ask for reasonable variances.
I do have there is a letter of opposition.
Yeah, I saw that. The one that came in way past our deadline.
Yes.
Yeah. I guess we don't have deadlines. You want to read that real quick? I was looking for it and I didn't have my hands on it. I saw it at 4:30 or 5:30 or whatever it was that came in.
Yeah, bear with me 1 second.
Now, does anybody think that this is reasonable and we should proceed? Any of you board members?
No.
All right. Tammy, go ahead.
I have it if you don't have it.
Oh, okay, Marilyn, you should read it.
It's from Mike Papp, I believe. To the Zoning
Yes.
Board of Appeals. I am in opposition to the granting of variances for 4 France Street. The property is existing non-conforming with 6 units in a single-family zone. Expansion of a non-conformity is not allowed under Norwalk zoning regulations. The owner operates his contracting business from this location and stores commercial vehicles and equipment not allowed in a residential zone, in parenthesis. There is no zoning hardship, and I would ask the ZBA to deny this application and require the new structure to be removed. Thank you, Morgan and Michael Papp, 3 France Street.
So either we proceed, and I don't think this is going to pass, hearing from the board, or the applicant withdraws, one or the other.
Now, if we withdraw the application, well, we have to withdraw the application, but he's also thinking of applying for a redistricting to commercial property. Is that something that you would consider?
You mean, is he going to go
Not
to
down
zoning?
France
He's going to
Street,
go
I
to the
would.
zoning department and ask, right?
Yes. Yeah, we.
The ZBA, yeah, the ZBA doesn't hear those cases, Cindy. We told
Right.
you that would be an application to the Planning and Zoning Commission.
There
Okay,
is a way the ZBA would hear it, but I don't want to go that direction.
yeah,
Yeah, you should go to zoning.
okay,
Thank you, sir. We do that.
so you are withdrawing the application? Today.
This month.
Yes, we're gonna withdraw the application,
We
sir,
go for the change in the zone.
and we'll go change the zone, as he says.
Well, there's no one
Before
left. You
you-
either withdraw or you don't.
Well, that's what he stated that he's withdrawing the
Withdraw.
application for now and moving forward with planning and zoning to redistrict.
All right, that's fine. So we consider your ZBA application withdrawn.
Okay,
Yes, sir.
Thank you.
Yes, sir. We will withdraw.
All right, so there's nothing to vote on, folks. Next would be, do we have some minutes? I think we do, don't we?
Yeah, we have the February minutes, February 17th.
One of the things we have to do in the future is make sure we get this stuff early enough that we can read through it and digest it and ask questions if need be, and look at the properties if need be. We're getting applicants giving us information later and later and later and later, and that's just not working for me. I mean, we have a 4-day rule and we also have a 4-hour rule. If somebody wants to comment on this stuff, they have an alternative. If they can't get us a letter within the framework that we provide, they can come to the meeting and address us. But 5:30 in the evening or 6:30 in the evening, when we have a meeting at 7:30 isn't good. I don't want to see that
We
happen.
just deny seeing it, that's all.
Well, I don't want to do that, but our staff is receiving these things. Our staff should send it right back to them and say, well, attend the meeting because you missed the deadline. I see the February 17th draft minutes. Has anybody had a chance to look at them? Danielle wouldn't normally vote on this because she wasn't at the meeting,
And neither was I.
and neither were you, so you wouldn't vote on it. Marilyn, how about you? Tom,
Well,
Yeah,
I-
I'm all right.
Yeah,
I like
you're all
that.
set?
Yeah.
All right. One of the two of you go ahead and move them, the other second, and then we'll vote.
I'll approve the minutes.
okay,
and-
I'll second it.
And seconded, and all in favor say aye. Who can vote? Aye. Aye, all right.
Aye, aye,
And not voting are Lee Levy and Daniel Sanchuk. Do we have any other business? I think people are probably tired. If not from the meeting, they're tired from reading every damn thing.
I have a question. When will this become non-virtual?
Good
I was
question.
hoping this would happen months ago, but there always pops up a reason that the mayor has decided to continue the policy of it being virtual. Do you have your?
When I asked
In perpetuity.
when I asked Tammy that question this afternoon, the answer was an unofficial 6 months.
That was a super uneducated guess.
Wow.
It isn't going to happen immediately. That's for
It was,
sure.
it's just a hope.
It'll probably happen the way everything else has happened. You just sort of, one day it'll just happen.
And may I ask a quick question, because everyone is tired? Specifically for Andy and Lee, if, there are times that I've been reading all these papers and I like to bounce things off of you guys.
Call me anytime.
Okay.
Please do. You always have in the past.
What we can do is we can get aid from each other in understanding things, but we can't discuss reaching a decision.
Correct.
In other
I
words, you
understand.
can't say, how do you feel about voting for or against something?
No,
You
I
don't-
understand.
You don't want to do that.
Right. No, it's really just for better clarification of things that
Sure.
I think is, okay, very good.
Now,
Andy,
I want to be clear about what I'm trying to achieve.
you're
I'm
breaking up,
trying to
Andy.
put down and put to rest, and we don't have to be demons to accomplish that. We can stick with the statutes and the ordinance, and I think we can be fair people. But we're just not going to brush things aside and say, well, hell, what the heck?
No, I agree.
That's how we got in trouble, and we ought not to allow that.
So
Anyway,
we
if you don't agree
actually
with me,
have
let me know.
We have a member of the public raising their hand now. I don't know for
I
what reason.
actually posted a question in the Q&A and they were just wondering the continuation of the flood hazard appeal, when that would take place again, which I believe would be at the next meeting, correct?
April 21st.
April 21st. So
Yeah,
Robert.
you got to stay on top of it, because sometimes when people realize they have a losing position, they withdraw. So it doesn't necessarily mean that's going to happen on that date.
They can contact the office.
I cannot believe the last one we dealt with tonight. I mean, that's ridiculous. Do we tell these folks when they come in that they're just being way out of line?
So I can't tell them that they cannot apply, but what I emphasized to the representative and the property owner was that I would not support this, that there's no justification for it. There's no zoning hardship. Feel bad, I really feel badly for his loss, but that doesn't warrant.
Well, but when you fly straight into the face of statutes and ordinances and you're forbidden from doing something, then saying, I want to do it anyway, it's just
Yeah.
sort of.
Well,
He continued to, the building inspector and I were out on site telling him to stop work, and he continued to stop work. So I'm sorry, he continued to work. We kept getting calls that he was out there working, or
Yeah.
having his, crew do
I
it.
thought we had a way of stopping it, that the zoning enforcement officer could go out there with the police, because that's happened in Rowayton. And
So we
work
had
was
the
stopped.
injunction, yeah.
Yeah,
The injunction it's difficult. Yes, you can get, not through the cease and desist that, or the zoning violation process that he was under with us, but through the injunction that had been granted by Superior Court. Corporation Council, explored whether it was, I don't want to say worthwhile, that's not the term they use, but
well, I guess we don't do it very often, but the one in Rowayton where the attic became a third floor instead of an attic, the zoning enforcement officer not only brought the work to a halt, but forced them to disassemble the third floor.
that may happen with the injunction, but we're just not there yet.
Okay, all right.
I am aware of one municipality that I will not name that took it to the extent that they had padlocks installed on the doors to the house to
Oh, my.
prevent access by the owner because the violations were so egregious.
Yeah, and well, I don't know that we want to be doing that, but if necessary, if we have somebody who just doesn't give a darn, then we might have to go to those measures, because I don't want to see people deciding zoning just a pain in the tail and they're not going to abide by it.
Well, that seems to be an attitude that has been around in Norwalk for
For a while.
35 years.
All right, well, I don't want to be draconian, but I do want to be tougher than we have been.
Well, I agree with you, Andy. I think that, we need to abide by the regulations when and where we have to.
And the reason that I was so insistent about that we deal with an appeal first and then any variances that might follow is really they're two separate decisions.
Absolutely.
If a zoning officer reacts reasonably, I'll support the zoning officer. There may be a question of the zoning process and the results, and talk about what's really there on the ground and some decisions that have to be made about variances and whether we make them. I mean, we had some stipulations and we've done that before where the applicant comes in and says, there's no change. There's absolutely nothing we can do with this building. Oh, but we do have a little grassy area in the back. Well, those kind of things bubble up when you say, we want you to try and give it a shot and look for ways to be, less out of whack with the zoning code. I don't like people to be deliberately non-compliant.
I agree.
Creative solutions are always best.
I believe that's the case. Anyway, I know you guys think I talk too much, so I'm not going to say another word. Lee, you want to take us out?
I make a motion that we adjourn tonight's hearing.
All in favor?
Second that.
Aye. All right.
Aye.
Thank you very much. I appreciate it.
Thank you,
everyone.
Danielle.
I know.
Nice to meet you, Danielle.
Nice